Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Apparently, Mr. James Owens filed a motion for a new trial late yesterday, which was November 4th. Saw it on the Orange County Court Records website. So we're going to go over it. And I was fortunate enough to hear Peter, the lawyer you know, talk a bit about it earlier today, as well as Emily Baker, both amazing attorneys. And so I kind of have some insight. Some of the stuff I already thought, but they're the experts. I'm not, as far as the law is concerned. But they did answer a couple questions I have as far as the biggest question being, will this motion be heard before her sentencing on December 2nd? Likely, yes. That is according to Miss Emily Baker. So I will also include both of their links in the information of this video because they are both excellent lawyers to follow if you are already not following them on YouTube. So this was filed right before 5 o'clock on 11/4, which was Monday. It's the state of Florida versus Sarah Boone. Defendant's motion for a new trial. We kind of should have seen this coming because Sarah, she excels at everything. Well, she sure excelled at getting a quick verdict. And she and her attorney, he's not going to be there for a potential appeal, but he's apparently going to help her out up until the sentencing. So I guess we can say bravo, Owens, if you want to give him any accolades for that. I have my love-hate relationship for the man. But, alright, let's jump into the motion here. Comes now the defendant, Sarah Boone, by and through counsel and pursuant to Rule 3.600, Florida Rules of Criminal Procedure, files this motion for new trial, stating in support thereof the following. The defendant was found guilty as charged of second-degree murder on October 25th, 2024. Well, that's a fact that we know. And we all know she was offered plea deals twice. Once in 2020 and once beginning of October. And she sure as heck thought, I'm going to skate on this one. Well, Sarah, that didn't happen, did it? Number 2, the instant motion is timely filed pursuant to Rule 3.600. I believe they have to file, from what I read. I did read up a bit about this stuff because I wanted to be somewhat informed. That you have to do it within 30 days of the trial, from what I understand. I could be wrong about the exact timing, but I believe it's like 30 days. 3, the defendant asserts that she is entitled to a new trial under Rule 3.600 on the following grounds. The court erred in ruling that the defendant was not entitled to court-appointed counsel. Okay, now this particular one, I don't think Kranick's going to buy it. And yes, from what I understand, Kranick will be hearing this motion. So that's another question people had. And I was pretty sure he was. And he is. So I don't think this is going to fly. But I have heard that people say that that's a possibility that could be kind of a question mark. But she did have 8 other lawyers. 8 other lawyers. As we know, Sarah doesn't play well with others. And I'm surprised she played well with Owens, but they also seem to be 2 peas in a pod. So it looks like the court erred in denying undersigned counsel's multiple motions for continuance. Alright, again, I think this is going to be tossed out the window because, remember, Judge Kranick said, despite an emergency, nothing would delay this trial. And Sarah wanted the trial to go forward. She was ready to go, okay? She was going to have to represent herself. It's that ad, and when Owens is like, no one should have to represent themselves. Everyone deserves a lawyer. And that's great for him, but he came into this, he knew that the small window that he had, Cranick made sure that was very, very clear. Now, did I believe that maybe the judge could have given them a bit more of time with the continuance? Sure. But again, Judge Cranick was not backing down. And they did have an extra week, remember, because of the hurricanes? So he had a little bit of a continuance due to Mother Nature. 3. The court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of the jury prior to deliberations. Okay, this is actually good timing because I just went over the state's closing yesterday because I hadn't done it before due to my crazy schedule last month. They did get up because, and I think the folks that did say the mom never did see that video, but they did not make a outburst. They merely got up and were escorted out of the courtroom. There was no utterance. I didn't hear anything. And as far as I heard, people in the courtroom didn't hear anything. So, and Owens didn't say a damn thing about this until later on. So that objection, remember he objected, that was not due to the family, apparently. So yeah, I think that one is out the window. IV. The trial court failed to disallow the testimony of the state's rebuttal expert witness, Dr. Tanya Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion. Well, I don't think that's going to fly because you guys kind of tossed a lot of crap out there toward the end too. So, yeah. And V, the state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Wow, that is grasping at straws, Mr. Owens. They merely came out there and proved, they went back out there and they said, hey, listen, suitcase. He was killed in a suitcase. This was his coffin. Boom. He is not happy because they lost. And this battered spouse garbage, the jury didn't buy it. I personally believe the jury knew early on what they were going to do. I don't know what point, obviously. There may have been one or two that were a bit hesitant. But I think that the state did all they needed to do in the original closing argument. As far as the rebuttal, no, it was a rebuttal, sir. And you went on and on about reasonable doubt and crap. So they had to sit there and listen to that. All right. Argument 1. The trial court erred in holding a defendant was not entitled to court-appointed counsel. In the above styled and numbered case, the defendant had approximately 7 court-appointed attorneys prior to the undersigned counsel taking your case. Okay, so if you're going to be technical, yes, 7 were the court-appointed, and 1 was, I believe, her ex-husband paid for originally. So, okay, we'll go with that. Let's see. Undersigned counsel took on the above case because he was concerned that Miss Boone would not have an attorney to represent her at trial. Yeah, you said that. So you said that in multiple interviews, sir. The above case was very complex, even for a seasoned trial attorney who was the public defender of the First Judicial Circuit for years, as well as having a thriving private practice. Is he bragging about himself? It was apparent to undersigned trial counsel that Miss Boone would be grossly ill-prepared and unequipped to handle a trial in this manner, or in fact to handle any other phase of the trial without counsel. Duh. Remember though, she said that she was a straight-A student. She excels at everything. So why not excel at being a last-minute attorney? But Owens knows, like we do, she would have fell flat on her face. Both the Sixth Amendment as well as Rule 3.111 Florida rules of criminal procedure guarantee an indigent defendant the right to appointed counsel. See Boone versus State 150 Southern 3D 264 and State versus Kelly 999 Southern 2D 1029 and progeny. There appear to be two exceptions to this precedence. I, if the defendant physically harms or threatens harm, R, battery, etc., his or her counsel, and II, if the trial court certifies that the defendant will not be incarcerated if found guilty, i.e. a judge trial. Okay, so she was given 7 attorneys. She couldn't play well with others. And she did threaten at least a couple of them. And she definitely verbally abused them, from what I understand. And all we have to do is look at her letters and the things that were happening in court between Judge Wooten and Judge Kranick. And I do think that that could sort of be, go for that. Should the court determine the defendant is not entitled to court-appointed counsel due to misbehavior on the part of the defendant, yep, Sarah Boone fits that criteria right there, the court must follow a process which protects the individual's right to due process as well as the defendant's right to the assistance of counsel. In the instant case, undersigned trial counsel would assert that Ms. Boone's behavior did not rise to the level of misconduct to warrant a waiver of the right to court-appointed counsel, and if the court determines that she waived her right to court-appointed counsel, then the court failed to warn her or inform her that continued misbehavior would result in a waiver of the right to court-appointed counsel. Wow, that is a crazy sentence there. Under controlling precedents, failure of the court to appoint trial counsel can result in a motion for new trial being granted. I think Judge Kranick was very clear on that, and we can kind of rewind and pull out all the transcripts, the video from Law and Crime, Court TV. I think that that's pretty easily proved that she was warned, because hell, I knew it, and I know all you guys knew it as well. Under controlling precedents, Rule 3.111, Florida Rules of Criminal Procedure, and the 6th Amendment, the defendant through counsel moves the court for a new trial. Denied. Guarantee it. Again, she was warned. She was given multiple attorneys. As a taxpayer in the state of Florida, this is disgusting. The fact that Owens felt sorry for her, and he may say, oh, I didn't feel sorry for her. I just felt like she deserved a lawyer. Well, you kind of felt sorry for her, dude. And that's fine. I mean, totally your thing. And I think that you're right about the one thing you did say initially, is everyone deserves a lawyer. Yes. But also, if you can't work with the lawyers that are provided to you, after a certain point, that right's going to be taken away. And that's exactly what happened in Sarah Boone's case. Argument 2. The court erred in failing to grant defendants' motions for continuance made by undersigned trial counsel. The court shall not deprive a defendant of his or her right to counsel of their own choice. Failure of the trial court to grant a continuance will result in a new trial should the court deny said motion for continuance by new counsel. And then, of course, he's referencing all these cases here, which I'm not going to read. So, all right. Owens, remember when you came on board? I know he's going to go over this, so we're going to continue to read. But remember when you came on board and you had just over a month? I think it was 45 days. I don't have the exact number in front of me because this has been a long, long process here. But remember when you came on and Judge Kranick said, we are not doing any continuances, extensions. Trial is going to be held in October. That's it. And you went with it. Yeah, you tried to get continuances, and I don't blame you. That's something you should try. But Kranick was very, very clear on this. In the instant case, when undersigned counsel came on board, the case was 4 years old. Actually, it was over 4 years old, but okay. Undersigned counsel filed his notice of appearance on August 30th, 2024. This gave counsel 45 days to prepare for a second-degree murder trial. See, I didn't even look at that, and I knew that it was 45 days. So I'm going to give myself a little pat on the back for knowing the number. All right. He immediately and aggressively began to prepare for trial. Yeah, well, after he did some interviews first, with the media. Undersigned counsel did his best to prepare for trial by traveling to Orlando from Milton on multiple occasions, both for meeting with Miss Boone and attending multiple hearings. Well, I hope you have an e-pass or some other toll discount program for you. And that was your decision, dude. You are the one that volunteered yourself as tribute to Sarah Boone. So, it's hard to feel sorry for your little travel time to Orlando from Milton. Despite his best attempts to prepare for trial, it was impossible to adequately prepare for unseen issues arising during trial. A prime example of this would be reviewing hundreds of pages of text from Miss Boone's seized cell phone, viewing all records of prior contact with Miss Boone and the alleged victim. He is the victim. He's not an alleged victim. He's a victim. He was murdered. Sorry. All right. With law enforcement, including inadmissible hearsay by the victim to law enforcement regarding Miss Boone being the aggressor at times. Yeah, we're not going to read the alleged word there. Counsel, for all purposes, closed his law practice down to prepare for the trial, but due to the short time frame, even with the assistance of other attorneys, was simply logistically unable to be as prepared for trial as he would have liked to be, and as Miss Boone was entitled to. Boo freaking who. This was your decision, dude. Owens, just take it. Just take your lumps, man. Yeah, you didn't have a lot of time, and you had a team there. You had 2 other lawyers with you, okay, and you had some ladies. I think that one of them was a new attorney, and the other one was a paralegal. And then you had Margaret, I forget her name. I think it's Margaret, back at the office. She seemed to work her ass off all the time. But you had a team. Do I think that 45 days is like a crazy amount of time? Yeah. But again, you came into this with all the knowledge that this was the time frame. This was what you were going to have. And you said, okay, let's play ball. Under the controlling cases cited supra, the court's failure to grant undersigned counsel's motion for continuance should result in a new trial. Yeah, that's not going to happen, buddy. I think that will be your other argument too, will be denied. And I cannot wait until Crane goes through all these. I feel like I'm going to have to sit there with some popcorn. All right, argument 3. The court erred when it denied a motion for a new trial due to an emotional outburst in the presence of the jury. This is the weakest one of all, in my opinion. Prior to jury deliberations, the victims, not the alleged, dude, George is dead. Sarah is not. Sarah zipped him up in a suitcase wherein he died, and he was murdered. So he's not an alleged victim. He is a victim. Period. Family members began to audibly and visibly get upset and departed the courtroom. They did get upset, but it was not audibly, and I don't believe the jury heard it because even the cameraman and a lot of folks around him didn't hear it immediately. And they got up, and I think they left pretty quietly, in all things considered. And did the jury even know that was his family? I mean, they may have known the brother, but did they really know that was his family? I doubt it. Undersigned counsel timely moved for a mistrial, requesting a new trial. Yeah, that was one of your many times that you were like, we should have a mistrial. Can we have this dismissed? Many, many, many times did you annoy the court with those. The court did not give any pervasive instructions or address whether the outburst could adversely affect the jury's deliberations. Florida appellate courts have held that the failure of the court to grant a curvative, I'm saying that completely wrong, instruction or a mistrial can result in the necessity of granting a new trial. Well, if it was that YouTuber or whoever it was before the jury came in that one day, because that person made an outburst, maybe we could have something here. But again, the family did not make an outburst, not even remotely. And I also think the jury, that wouldn't be made a difference in it at all. And then, of course, he's citing all these cases. The court is unable to determine if this outburst affected the jury's decision because no inquiry was made. Under controlling precedents, the defendant is entitled to a new trial. Well, I think you could have asked that on Friday. You could have said to the jury, did this outburst affect you at all? You didn't bring it up, at least not to any extremeness at all. So, again, this one is a weak argument. All right, argument 4. The court erred in allowing the opinion of the state's expert not previously disclosed. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Werner, after the state failed to disclose before trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. This issue was discussed extensively in the expert witness's deposition taken on October 4th, 2024. The state committed prosecutorial misconduct by failing to disclose this new opinion, as agreed in the deposition mentioned above. In addition, the state's expert opinion on whether the defendant perceived an imminent threat necessary for the justifiable use of force in battered spouse syndrome testified to before the jury was improper. That's an awkward sentence there, sir. The state's expert, Dr. Tanya Werner, admitted she had not listened to the defendant's testimony before the jury before forming her opinion on this ultimate issue of fact. In addition, Dr. Werner failed to listen to the testimony of Dr. Michael Brannon and Dr. Julie Harper before expressing her opinion. Well, I think that the fact that she didn't listen to the testimony was really stupid, but I don't really think that her testimony was vital at all, in my opinion. So I don't even know if the jury paid too much attention to it in the end. I think the major things that made this jury go with their guilty verdict was the video evidence. Let's just be honest. All you got to do is see Sarah telling him to shut the F up, and then all this body cams from all the times that she called 911, and all her video tortures of George. So I think those alone, and seeing the suitcase, I think that was all the state really needed. Furthermore, the state's expert testimony on this issue, whether the defendant perceived an imminent threat at the time of the event, violates the providence of the jury. Witnesses are prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury determine what occurred. When a witness is asked to express an opinion that applies a legal standard to a set of facts, the opinion testimony is generally inadmissible. Well, they always say too that witness testimony, the jury can decide whether they pay attention to it and believe it or not. So, it was up to them if they listened to any of them. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. This testimony may interfere with the function of the trial judge to determine the applicable law and instruct the jury thereon. So, yeah. Again, I don't think that the testimony really meant too much to the final verdict, the final decision of the jury, but that's just my opinion on it. You guys let me know what you think. Argument 5. The prosecutor committed misconduct by using rebuttal argument to make a second closing argument. Look how short this one is. The state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Counsel for the state made a second closing argument posed as a rebuttal. How horrific. Wherefore, premises considered, I like how he put that in all all caps. The defendant seeks the relief sought herein as well as any other relief to which she may be entitled. The defendant requests a hearing in this matter. She's not entitled to crap. She's not entitled to crap. And of course, there's a certificate of service and James Owens. All right. So, in my opinion, she's entitled to nothing. She had a fair trial. And how often did Judge Kranek ask her, "Are you satisfied with your legal counsel?" She said, "Oh, yes, I'm very satisfied with them." "Has there been any witnesses that they haven't called that you would like?" "No." He asked her multiple times. I'm thinking at least 3 or 4. It might be more. If anybody knows the exact number, let me know in the comments. I'm actually curious. I can go back and count, but that would require a lot of watching. So, the bottom line is, I think that this motion is worthy of the garbage. And no disrespect to Owens. I applaud him. I will applaud him for his hard work, because I know he worked hard. Okay? I applaud him for his hard work, and I applaud him for feeling as though he wanted to step up and help someone out. But as far as all these other arguments that he wants to toss out, that Sarah was mistreated, she deserves a new trial. No. I cannot wait. I cannot wait until the state responds to this. I cannot wait. And hopefully, that'll be tomorrow. Because if they saw this Tuesday, which is today, as I record this, they're probably been working on it today. And I'm really hoping that Mr. William J. writes it. Because I love his emotions. I really do. But, alright guys, let me know what you think of this. I know you all have opinions on it. And again, it does seem like this particular motion for a new trial will be heard. So this will probably be heard this month. I don't know exactly when. And of course, I'll keep you guys apprised of when I do hear that. So it'll definitely be heard before December 2nd, from what I understand. Alright guys, I hope you have a great rest of the day. And most of all, stay safe.